Ladies and gentlemen, welcome back. Welcome back, and please take your seats for this session 2 of the plenary sessions, which is titled the Pacific Countries and International Arbitration Reform. We're running exactly to time, and we have logging in now all our panellists and speakers. Our speakers are, and I welcome them all, the Honourable Tatufu Toma Mokai, Minister of Trade and Economic Development of Tonga, the Honourable Caleb Uduai, Minister of Finance from Palau, Dr. Eric Kwa, Attorney General, Department of Justice and Attorney General, Papua New Guinea, Dr. Manuel Carres da Costa, Minister of Justice from Timor-Leste, Christina Park, Principal Counsel, Team Leader, Law and Policy Reform ADB, and the Team Leader on this particular reform. And I'm also part of the panel for this session. Our moderator is Mr. Gary Bourne, who joins us from London. He is the International Arbitration Practice Group Chair of Wilmer Cutler Pickering Hale and Dorr. He's President of the SIAC Court of Arbitration, and he is also a consultant to the Asian Development Bank on this law reform. Welcome all.
Thank you so much, Daniel, for that kind introduction. You've saved me part of the work of introducing this all-star panel, a truly exceptional panel to report on recent developments with respect to the New York Convention in the Pacific Islands. A couple housekeeping matters to touch on just before we begin. First, if the panelists could keep their speakers on mute, their microphones on mute when they're not delivering presentations. And secondly, for the audience, there will be from Timor-Leste a presentation in Portuguese, but there are English translations available on the platform. I think you can see the application if you wish to listen to that in English as opposed to Portuguese. I'd like to begin by thanking ADB and all of you, both for the invitation and also for attending today. It's a great privilege. It's an honor to be able to discuss a topic that is so important to the region, so important to the world. Let me say a few introductory remarks about our topic, the New York Convention, before we turn to the substance of this session, turn to the country reports, the developments, the very important developments that have occurred in the region over the past several years, in significant part because of the assistance, the technical assistance of ADB. We all are familiar with the importance in international trade and international investment, cross-border investment, of international arbitration. Unless there's a reliable or secure means of dispute resolution, then businesses won't trade with each other. They won't invest in foreign jurisdictions. Businesses have, both in Asia, in the Pacific, and elsewhere all around the world, looked for decades now, centuries indeed, to international arbitration as the most reliable means of resolving their cross-border business disputes. Hopefully those disputes never arise, but if they do, arbitration provides, in the view of most businesses, the least bad way to resolve those disputes. It's in large part because what some have called the 5 E's of international arbitration, which I think today we can extend to 6 E's. Those 5 E's are that international arbitration is more efficient and more expeditious than the alternatives. For similar reasons, it's also more expert, and particularly in international matters, it is more even-handed. The 5th of those E's is that, again, in international arbitration, in international matters, arbitration is more enforceable, in part because of the New York Convention, as we'll see in the course of this session. And finally, the most recent E to join the 5 that we've just considered is that international arbitration is more electronic than the alternatives. This conference, held virtually, is a good example. Let me say just a very short word about each one of those E's. International arbitration is both more efficient and more expeditious because its procedures are tailored to particular disputes. They're not, as with many national court civil procedure rules, one-size-fits-all rules that are imposed upon the parties, taken off the shelf for every dispute. Rather, parties, using their procedural autonomy, tribunals using their procedural discretion, can tailor procedures in individual disputes to what best suits the parties for an efficient and expeditious resolution of that dispute. Many arbitral institutions, like the Singapore International Arbitration Center, like the ICC, have also developed fast-track procedural rules to ensure that smaller value disputes are resolved exceptionally quickly. For some of the same reasons, our international arbitration is more expert. The parties select the tribunal. They know best what their dispute concerns, what types of expertise are important. After a dispute arises, parties can select the arbitral tribunal, taking into account the subject matter of their dispute, the applicable laws, the languages that are involved in the particular dispute. Rather than having a national court judge who may speak only one language, the wrong language for a particular dispute, and who sadly must decide every conceivable type of dispute, from criminal to tax to administrative law to constitutional law disputes, as well as just possibly the commercial law disputes that the parties bring to her or to him. The arbitral tribunal can be selected based upon the subject matter of a particular dispute. International arbitration is more even-handed in that you have a tribunal that both parties. Instead of home court justice, which parties inevitably seek in litigation, one has an even-handed tribunal that is composed of tribunal members from both the parties' home jurisdictions, possibly, and a presiding arbitrator from a neutral jurisdiction. International arbitration is more enforceable, as we're going to see, because of the New York Convention. Because of the convention and its 167 contracting parties from all around the world. The convention requires those contracting states to recognize and enforce both international arbitration agreements and, importantly, international arbitral awards. If parties agree to arbitrate, the convention requires, and contracting states have so applied the convention, that they be directed to arbitrate, that their dispute be referred to arbitration, and that once the arbitration is concluded, then the arbitral award will be recognized, subject to only very limited exceptions. The convention is, in a sense, a passport to the world of international trade and investment. It provides a reliable means for ensuring that dispute resolution agreements and the ultimate awards from those agreements will be given effect. It provides traders and investors with the legal security and certainty that they and their shareholders demand. And finally, international arbitration is more electronic. In the age of COVID-19, when in-person hearings, at least in many countries, are not possible or not realistically practicable, international arbitration has moved to platforms like these every day. Zoom hearings or WebEx hearings are conducted remotely, allowing parties to resolve their disputes just as efficiently, arguably more efficiently than before COVID-19 struck. And so, for all those 6 reasons, the 6 E's, businesses demand international arbitration as a requirement, a condition to trading on equal terms, to investing on reasonable terms in order to obtain security for their investments and for their trading practices. Thankfully, the countries in the South Pacific have, over the last 5 years, begun to accede to the New York Convention, to ratify the convention, as well as to adopt the UNCITRAL model law. What we're going to do in this session, the heart, the substance of this session, is to hear from each of the various participants that Daniel referred to about the actions that they've taken, the measures that their respective states have adopted with regard to the New York Convention and the UNCITRAL model law. It's been my privilege to introduce an all-star panel, and if we could begin with Papua New Guinea with Dr. Eric Kwa, the Attorney General of Papua New Guinea, to describe for us what has happened with respect to PNG's accession to the New York Convention. And after that, we'll turn to Palau. Dr. Kwa, if I could, perfect.
Myself, thank you. Do you hear me?
Yes, we can.
We hear you very well.
Right. All right. Thank you, Gary. Thank you to your team and also to ADB for giving us the opportunity to participate in this very important forum. And I also acknowledge our other leaders of the region who are listed on this panel and who will participate in this meeting. Let me just give you a rundown on what we've been doing since we acceded to the New York Convention in 2019. My department has been a very critical partner to the team of Papua New Guinea agencies who have been working on the draft bill that we want to try and comply with the international model law. So what we've done is that we've been working on this bill for the last 2 years. And the Arbitration Technical Working Committee has been looking at the international best practice and then looking at our current regime and trying to address a new modern system for us as a country. So last year we did develop a draft bill to comply with the model law to repeal our Arbitration Act of 1951. That is the existing legislative framework on arbitration in Papua New Guinea. As you can see from the date, it's the year it's 1951, and so that's pretty old. And that was a law that was in place before Papua New Guinea became independent in 1975. And so, as you can appreciate, the act is outdated and requires a lot of work to overhaul it. And as you can also realize, it predates the United Nations Convention on the Recognition and Enforcement of Foreign Arbitration Awards. That's a New York Convention, and so it's not consistent with international best practice. So there are no arbitration institutions to support arbitration seated in PNG, and therefore we require parties to resolve the dispute by foreign arbitration institution. Apart from agreement by the state in arbitration involving foreign investors, whereby the state waives its immunity to allow the enforcement of foreign award in country, there is no legal basis to facilitate enforcement of arbitral awards in the country. And so what we're trying to do is that in the bill, we would like to provide an update legislative framework for arbitration in PNG by introducing mechanisms that, amongst other things, facilitates the recognition and enforcement of arbitral awards and address other limitations identified with the existing arbitration framework, as I said, that goes back to 1951. So our bill has four overriding objectives and purposes. These include to encourage the use of arbitration as a method of resolving disputes. 2, to facilitate international trade and commerce by encouraging the use of arbitration. 3, promote consistency between PNG's arbitration regime and international best practices contained under the unilateral model law, and facilitate the recognition and enforcement of arbitration agreements and awards. This is very important to PNG because we have a lot of foreign investors who have invested in this country, and they would like to be encouraged and be given confidence that if they're able to take us to the international tribunal, we can be able to facilitate the enforcement of their arbitration agreements. We also want to ensure that the bill gives effect to the New York Convention. So on a broader perspective, the bill embodies a strong commercial arbitration framework that will boost investor confidence. The bill will also reform the regulation of arbitration within PNG and enhance it to conform to the unilateral model law that addresses and provides a framework for domestic and international arbitration that is harmonized with international law and standards. Now, in terms of PNG's accession to the New York Convention, as I said, we did accede to the New York Convention on the 17th of July, 2019. And so the proposed arbitration bill of 2021 is drafted to satisfy the treaty ratification requirements, which are clearly outlined in the Constitution of Papua New Guinea under Section 17. There is to be an act of parliament in place to give effect to international treaties to which PNG has become a party. And so because we became a party on the 17th of July 2019, since then we've been developing this bill to ensure that we domesticate the New York Convention. This will enable PNG to join the global arbitration community and further enhance PNG's effectiveness as an investment destination. As with other jurisdictions, PNG's arbitration bill also incorporates the provisions of the model law and makes some adjustments to suit PNG's context. In particular, we consider the interaction with the local courts. The model law is designed to operate in conjunction with the New York Convention as it provides procedures for the arbitration of any disputes between parties. Now, what does it mean in terms of our local context? Papua New Guinea will soon adopt its national framework on conflict resolution and prevention. And here I would like to thank the ADB and our other partners who have been helping us to develop this framework in the last 2 years. And so our Arbitration Technical Working Committee has brought this on board as a key priority to deliver. And so we want to deliver the bill to become law this year and also the national framework on conflict resolution and prevention. Both of them will go to assist in mapping out and enhancing the arbitration system in PNG. Once this framework is finalized and adopted, it would map out clearly the domestic arbitration system in the country and provide some clarity in terms of conflict resolution. And so I might add here that we currently have a dispute under the New York Convention, which has already been filed by a foreign investor who is not happy with the decisions of government. And so we are currently complying with the New York Convention to defend the state in terms of this arbitration. So, friends and colleagues, it is hoped that through these measures that PNG is trying to put together, the bill and the national framework on conflict resolution and prevention, these two instruments will then help PNG to strengthen its arbitration system. PNG already has a large foreign investment in this country, and we have got a lot of foreign investors, and we aim to ensure that investor confidence is maintained in various aspects, including through a robust arbitration framework that is informed by international best practice. So that's, Gary, that's what we've been doing, and we hope to achieve by the end of this year in terms of the bill and the framework. Thank you.
Thank you so much, Mr. Attorney General. That was extremely clear, extremely comprehensive, and I think of enormous interest to our audience. We're going to move now from Papua New Guinea to Palau, and we're also going to move from the Department of Justice to the Department of Finance. Our next speaker is the Honorable Caleb Udoy, the Minister of Finance of Palau. He's going to report on Palau's accession to the New York Convention and next steps with respect to a bill to implement the convention.
Good. Thank you, Gary and Ali, and good morning to everyone at this year's conference. I'd like to recognize first Senior Legal Counsel with the Office of the President, who's been instrumental in helping us work on the accession as well as the bill for international arbitration that we've submitted to Congress. He's joining us today from Palau, sitting to my right. I also want to thank the Asian Development Bank, UNCITRAL, previous conference hosts, Gary Bourne, Daniel Meltz, and Christina Pak, specifically for all of their help in getting us to where we are today. I'd like to report to you first on our accession to the New York Convention, status of the International Arbitration Bill that will implement the New York Convention, and some comments on next steps, what this means for business and investments in Palau. So this is the third conference on international commercial arbitration that we have participated in. I'm happy to say that Palau was the 163rd country to adhere to the New York Convention on March 31 of last year. The convention entered into force in Palau on June 29 of last year as well, 90 days after the deposit of the instrument of accession. When we acceded to the convention, we made two reservations, one on reciprocity and the other on commercial reservation. And unfortunately, we were trying to fast track this process. We had a bill ready, and we're not able to submit that to Congress because of the pandemic. So as of today, we have a bill submitted to Congress earlier this month, on March 10th, to implement the convention. Prior to the arbitration bill, Palau did not have an arbitration law in place. We did not have a legal framework for supervising arbitration. We did have several passing references to arbitration in some legislation, but no statutory provision dealing with arbitration proceedings in Palau. The bill that we have submitted for approval for enactment is the state-of-the-art legislative framework for international arbitration based on the UNCITRAL model on international commercial arbitration 1985 with amendments adopted in 2006, the model law. It implements Palau's obligations under the New York Convention and provides a modern legal framework for arbitrations in Palau. First, Article 12 of Part 3 of our bill obliges courts in Palau to refer parties to arbitration. Article 22 provides that the arbitration tribunal may rule on its own jurisdiction, and an arbitration clause that forms part of a contract is separable from other terms of that contract. And third, the arbitration bill also contains provisions on the granting and enforcement of interim measures. So these are well-established international arbitration principles. But we've also adopted some of the international best practices. First, inclusion of an emergency arbitrator in the definition of an arbitral tribunal. Second, provision that guarantees expressly the confidentiality of the arbitration proceedings subject to defined exceptions. Third, the inclusion of a provision that expressly deals with the liability and immunity of arbitrators, appointing authorities and arbitral institutions. Fourth, the inclusion of a provision on representation in arbitral proceedings. And this is in line with prevailing trend of recognizing parties' freedom to choose their representatives in international arbitration proceedings. So with the enactment of our arbitration bill, Palau will have one of the most advanced and comprehensive legislative regimes for international arbitration in the world. We're very proud of that once that happens. So what are the implications that we see from this New York Convention and our bill to implement the New York Convention? First, we recognize that more work is needed to implement the convention. Finalizing the adoption of the bill is the first step. But we also need to invest in building up our expertise in the judiciary, in the private sector, and with our lawyers, our local bar. So critically important that we do as much as we can to improve investment in Palau. I was fortunate enough to listen to the previous panel, and I enjoyed the discussion on foreign direct investment. The Asian Development Bank estimates that because of COVID-19 and our vulnerability to external shocks, our GDP was was expected to contract by 9.5% in 2020 and 12.8% in 2021. This year's budget of $100 million for our country is made up of about 40% borrowed money, which is a first for us and first for Asian Development Bank that funded a lot of that budgetary support. So by encouraging trade and investment, we can arrest these negative economic indicators. We also will be able to achieve Sustainable Development Goal SDG 8. But I guess the proof in the pudding is that we get more investment to our country and restart our economy. Previous to the pandemic, most of our investment was from Asia, in particular from China, which we don't have diplomatic relations with. So our government leaders looking for every opportunity to increase economic growth, turn to different initiatives like online gaming and offshore banking. I think this arbitration initiative will improve the quality of investment to Palau, and we can see better investment for our people. Next steps after this, once we have a system in place, is to work on insolvency legislation and more promotion of our business and industry and trade and investment. I expect that we will see a lot more of Asian Development Bank, who's been helping us tremendously with this type of assistance. So thank you. I'm happy to answer any questions later on if you have any about what I've raised. Thank you.
Thank you so much, Minister. I think 2 points that the Minister made are particularly important. First, that by acceding to the New York Convention, by adopting, as he says, state-of-the-art implementing legislation, one improves the quality of investment. If investors, if business people can rely upon what their contracts say, they're more likely to have reasonable contracts than the sorts of investments that countries frequently don't wish to have. And secondly, it's critical, in addition to adopting the legal infrastructure, the New York Convention, the UNCITRAL model law, to also ensure that the legal community, the business community as well, knows how to use those instruments. It's an ongoing process. It's an iterative process, but these tools need to be used as well as acquired. With that, I'd like to move again from Palau now to Tonga, and from the Minister of Finance to the Minister of Trade and Economic Development, the Minister, the Honorable Tatafu Toma Moeki of Tonga. Thank you very much, Minister.
We've got the slides up, which is good. If we could just get some audio, if it's possible to unmute, Minister.
I'm seeing slides, but I'm not.
You can hear me, Kerry?
You're just coming back now.
We're hearing you now. It's a little bit faint,
Hello?
but we're hearing you. Yeah, that's perfect. We hear you now.
Okay. Gary, can we go back to you because there's poor Wi-Fi reception at the moment from Tonga, I'm afraid.
Yes, perhaps from past experience with these sorts of things, if we didn't screen share and simply did audio, we might be able to hear from Tonga in the order that we had planned. Perhaps though, while we're exploring that technical possibility, we can move on to Timor-Leste and Dr. Manuel Carceras da Costa, the Minister of Justice. I hope, Minister, that I'm not putting you on the spot by taking you out of order. But I know you're prepared to discuss more or less accession to the New York Convention just a month ago or so, and I know our audience is keen to hear about that.
Gary? Gary? Gary?
Yeah, we're hearing you, I think.
Thank you. Senhor Moderador e demais oradores deste painel, distintos convidados, senhoras e senhores. Agradeço com muito agrado o amável convite que foi endereçado pelo Country Diretor do Asia Development Bank, Sr. Suni Mitra, a fim de intervir nesta conferência internacional sobre a arbitragem no Pacífico do Sul, atenta à importância crescente devotada a este relevante tema. Abordando especificamente o caso concreto de Timor-Leste, gostaria de destacar que a arbitragem internacional tem sido um tema de particular abordagem e atenção por parte do Governo e do Parlamento Nacional, tendo presente que a mesma tem um significativo impacto em várias vertentes da nossa realidade social, normalmente no setor econômico e, obviamente, comercial.
We are getting captions, I believe.
Por essa razão, a arbitragem internacional, enquanto mecanismo alternativo de resolução de litígios, assume uma relevância crescente na sociedade odierna, na medida em que o universo da resolução dos litígios não pode e nem deve esgotar-se no sistema estatal de arbitration da justiça. Creemos, pois, que se afigura decisiva a concessão do quadro legal que permita regular o recurso a esta via alternativa de resolução de disputas. No dia 2 de fevereiro do ano em curso, o Parlamento Nacional Timorense aprovou a adesão de Timor-Leste à Convenção de Nova Iorque de 1958 sobre o reconhecimento e execução de sentenças arbitrais estrangeiras. No dia 12 do mesmo mês, esse órgão legiferante aprovou com um número de votos bastante expressivo o regime jurídico da arbitragem voluntária. O aludido regime oferecerá a todos os cidadãos um serviço jurisdicional que permite uma resolução objetiva, imparcial, equitativa, útil e eficiente dos litígios. Importa notar que com a aprovação e entrada em vigor deste regime jurídico no ordenamento jurídico timorense, fortalece-se o sistema de administração da justiça, constituindo aquele um método alternativo de resolução de conflitos face ao sistema judiciário, por via do qual as partes em disputa poderão escolher os árbitros encarregues de solucionar o diferendo e a decisão final, revestida de força executiva, passará a vincular as partes em conflito à semelhança do que sucede com as sentenças judiciais. A par da aprovação do regime jurídico da arbitragem voluntária, realço que o Ministério da Justiça de Timor-Leste encontra-se a trabalhar na reforma da legislação atinente às terras e a preparar um pacote legislativo neste âmbito que, a merecer a aprovação dos competentes órgãos legiferantes, conferirão maior confiança ao investimento e assegurarão uma maior dinamização da nossa economia, atraindo para Timor-Leste o investimento externo. Estas medidas, a par da criação do quadro legal que ampare o recurso à arbitragem internacional, constituirão condições indispensáveis à celeridade e à segurança quanto à resolução dos casos em disputa, sem descurar a observância das regras internacionais, às quais nos encontramos adscritos, atenta a nossa adesão à Convenção de Nova Iorque de 1958, como supra enunciamos.
Permita-me ainda, neste ensejo, fazer uma alusão à Convenção das Nações
One that
Unidas.
there's an issue with the captioning, and I'm sorry that we haven't been able to have the captions come.
Compensação internacional, resultante da mediação adoptada pela Assembleia Geral das Nações Unidas em 20 de dezembro de 2018, a qual Timor-Leste aderiu em 7 de agosto de 2019. A semelhança da Convenção de Nova Iorque de 1958, a Convenção de Singapura faculta uma base legal uniforme e eficiente para o cumprimento de acordos internacionais que resultem da mediação, permitindo às partes invocar tais acordos, à semelhança do que prevê a Convenção de Nova Iorque sobre o reconhecimento e execução das sentenças arbitrais. Tratando-se de um instrumento internacional vinculativo, o mesmo conferirá estabilidade, segurança e certezas jurídicas às relações comerciais internacionais, salientando-se que a mediação complementa outros meios de resolução de litígios. Termino esta breve intervenção endereçando a todos os convidados e participantes o meu penhorado agradecimento pelo tempo dispensado que me ouvirem e formulo os votos sinceros para que continuemos a empenhar os nossos esforços na prossecução deste e de outros objetivos que nos são comuns. Muito obrigado.
Thank you so much, and also thank you for stepping in on actually not just short notice, but no notice at all. I think the translation worked perfectly well, and we thank you very much for that presentation. Perhaps now we can go back to Tonga and Tatafu Mueki. Minister, I think there's still an issue with the audio. There we go.
Hello?
Yes, we have you now.
Hello?
I think we're hearing you. We have the visual.
Hello?
Yes, Minister. I think we have you now.
I can't.
Yes, we have your audio.
Okay. Thank you very much.
I'm very sorry, but I think the audio isn't working.
The Wi-Fi is too poor to receive the audio from Tonga at the moment, so Gary, you might want to throw back.
I'm in your hands, Daniel. You are the supreme moderator of this conference. What would you like us to do next? I think the available options are perhaps moving to Christina Pack, who was going to report on.
Yeah, I tried before the video. Does it come across better?
That does work better, in fact. Why don't we, yes, Hello? Minister, why don't we go ahead without the video and just have you do audio? We appreciate.
I can hardly.
We appreciate flexibility. I'm very sorry, Minister, but we seem to have lost you again.
Gary, maybe we could move on to Christina.
Yeah, I think that makes sense. It's finally, and hopefully we can come back to Tonga, but if not, I'll say a few words about, just from a technical perspective, what has occurred there. But it's my distinct pleasure and honor to be able to introduce Christina Pack. In many ways, the ADB initiative in the Pacific Islands was her brainchild, and it was her leadership and inspiration that provided the foundation for a lot of the work that has been referred to. Christina, just very briefly, your whirlwind tour of the remaining jurisdictions where things have happened in the world of international arbitration in the Pacific.
Thanks, Gary. It's been an absolute pleasure to work with you and Daniel. And of course, with our developing member states, without stealing the thunder about Tonga, because Minister Moyaki has really good news to share about Tonga. So I will leave that update till later. Hopefully he could still connect. But, a lot has happened since we started this reform in 2017. And, you've heard about the good progress in PNG, in Palau, also Tonga, and of course Fiji. And in fact, this reform has progressed even during COVID times, and it's been one of the key reforms with respect to COVID-19 recovery efforts. And one note that I do have to say is that state-of-the-art arbitration laws, in the Pacific, I have to say, the Pacific has leapfrogged, and essentially, it has one of the most advanced international arbitration legal regimes in the world, and that's starting with the Fiji International Arbitration Act that was enacted in 2017. But also the Palau Bill, as Minister Khalid has pointed out, it is a state-of-the-art piece of law, and as well as Tonga, which perhaps maybe I can just, I'm not sure if Minister Moyaki can say it, but Tonga acceded to the New York Convention in June last year during the height of COVID, and in fact has now a brand new International Arbitration Act as of last year, and it is state of the art. But with respect to remaining countries, a lot of progress has been made, but there are still many remaining countries without an effective legal framework to resolve cross-border commercial disputes through international arbitration. For example, Samoa, Solomon Islands, Vanuatu, and among other Pacific countries. It is critical for the South Pacific countries and Timor-Leste to continue with this important reform, because in the Pacific, FDI still contributes to a higher proportion of their economies. And of course, with FDI comes jobs and many other benefits. And it is also critical to private sector growth, which also brings many benefits. So, as well as this, international arbitration it's important to meet the demands of the infrastructure demands, as well as growing the export and tourism sectors. And as mentioned by many experts, it has a major role to play in the post COVID-19 recovery efforts. And maybe some of you have tuned into our plenary session 1, when Professor Jordy basically talked about what Pacific countries should be doing, is that they should be getting closer, and they should be getting rid of the human-made frictions and provide a better contractual environment through international arbitration to help their economies grow. And that's in addition to really continuing other reform efforts to improve the overall business climate in the region. So in our last session 4, ADB will be conducting consultations along with our Pacific Private Sector Development Initiative to see how we can progress this international arbitration reform further in the Pacific region, and answer any questions that the audience, governments, other parties may have. So please join our last session if you'd like to find out more. Thanks, Gary. I'll hand it back to you.
Thanks so much, Christina. And I also bring news from Minister Moeki, who has very kindly agreed to share his PowerPoint presentation, which unfortunately the Wi-Fi issues didn't let us see in real time. But for those of you who are interested, it will be available from the sponsors of the conference. Minister Moeki was going to explain that Tonga ceded to the convention in June of last year, the 12th of June, with the convention entering into force for Tonga in September of last year, 90 days after the deposit of its instrument of accession. And as Christina mentioned very briefly, the Tonga International Arbitration Act, which implements Tonga's obligations under the convention, was gazetted and is effective as of January 3rd of this year. And it is truly a state-of-the-art piece of legislation. It builds on it. It implements much of the 2006 version of the model law, but it also adds some best practices by other jurisdictions around the world. Is state of the art. And I think handing it back to you at this point, Daniel, I think one of the key things is a point that Minister Uduai made in his remarks. Again, it is ensuring that the local bar, the local business community, in-house lawyers, external lawyers have the training capacity to make the most of these various instruments which have been adopted by all the hard work of the men and women you've heard from in the last hour or so.
Thank you, Gary. Yes, one of the things that is top of mind is really how each of these countries will benefit once accession and then implementation occurs. And the ADB has been very careful in this regard to ensure that a lot of emphasis has been placed on capacity building. So some of the things that we've undertaken is capacity building of business, capacity building of lawyers, and also capacity building of judges. You've heard today that Fiji was one of the first countries to undertake the implementing legislation. It did so very quickly. It had already exceeded in 2010, but in the course of really several months in 2017, it enacted its legislation. We conducted training at all levels, and I'm pleased to report already in Fiji there is significant activity in international arbitration. Not only is that reflected in some of the cases in the courts, there have already been some judgments, but a number of clearly arbitration clauses have already entered into commercial contracts, and you heard earlier from Fijian Business how that's occurred. But the benefit there is really that each of these jurisdictions is going to have an opportunity, the local bars and the businesses, to benefit from this. The bars, particularly the lawyers, in terms of advising on the arbitration clauses to start with, then advising on the disputes, and hopefully in the long term to be developing their own arbitration bars so that we have appointees from the South Pacific who will sit as arbitrators and be able to have a common pool potentially in the South Pacific region of qualified individuals who will be able to sit as arbitrator. So these are the on-the-ground potential benefits that are over and above the FDI aspect. Of course, the FDI aspect is front and foremost in terms of what we're doing. But there are going to be all these ancillary benefits as well. Structurally, many of these economies, PNG, Timor particularly, in terms of mining, oil and gas, they are structurally very suited in any event to international arbitration. They already have significant experience in international arbitration, although not necessarily with their countries as seats of the arbitration. but other countries as well. Palau, we heard from, are very heavily dependent on tourism, a country of about 20,000 people, but can swell to another 100,000 to 150,000 tourists in any particular year. So again, they have a very strong construction sector and other business sectors which will benefit from this. So in summary, I just want to say that really the capacity building will be critical, that even though some of these countries will start from a zero base of no cases, having had no arbitration laws, it will be very quick to build these up, because arbitration, international arbitration, has become the key dispute resolution process for business when we're dealing with foreign parties. And in that regard, this reform hopefully will bear fruit for all these nations in years to come. So I want to thank everybody, and I'll hand back to Gary, because I am the last speaker and I'm literally, and if you'll excuse the pun, eating into your lunch. So Gary, I'll hand back to you.
I'm not going to stand between the delegates and lunch, not even remotely. I do think it's important, though, that I thank all of the panelists. I think it was a whirlwind tour of a very, very wide geography and very diverse legal systems, but I think I at least learned a lot, and look forward to the coming panels as well. I'd like to thank again the audience, but in particular, I'd like to thank each one of the panelists personally. Thank you all, and I think you're released now for our lunch break. Thanks again.